Next topic, relevancy. Again, probably the most important of the five, 33%. Probative value is the most important thing here. It's a 4. Okay. In order to present evidence, that evidence has to have probative value. And there are 2 requirements for probative value. We've got factual relevance and legal relevance. So you have a piece of evidence that you want to submit must be both factually relevant and legally relevant, and you need to know the difference between these 2 things. So factual relevance is a threshold inquiry. It's the first thing you start with. In order for evidence to be admissible, it has to be factually relevant. And evidence is factually relevant if it relates to an event, person, or time at issue in the litigation. And you got to remember these key words here. If it possesses any tendency to make the existence of any fact that is of consequence to the determination of the action more probable or less probable than it would have been without the evidence. So if it possesses any tendency to make the existence of a fact less probable or more probable than it would have been without the evidence. Evidences can be direct evidence, and it can be circumstantial. These are just words that sometimes will pop up as an answer choice. I want you to just know what they are. Direct evidence is evidence that resolves the issue if it's believed. I saw the defendant stab the victim. Circumstantial evidence is evidence that requires an additional step of inference. I saw the defendant's car outside the victim's house at the time of the murder. So once evidence is factually relevant, the court has to consider whether it's legally relevant. And under the federal rules, Federal Rule 403, probably the only one that if there's a number you need to know on the test, it's maybe this one, 403. Factually relevant evidence can be excluded when its probative value, its usefulness in determining the case, its probative value is substantially outweighed by a danger of unfair prejudice, confusing the issues, misleading the jury, undue delay, waste of time, or cumulative evidence. But this is a balancing test. The probative value of the evidence on the one hand and the danger of these factors on the other hand has to be substantially outweighed, not just outweighed. And the big one in this balancing test here is unfair prejudice. And an example here could be like a lie detector test, not particularly useful in terms of their reliability, but you tell the jury that they failed the lie detector test. Well, wait a second, this is very, very unfairly, potentially prejudicial for something that really isn't that reliable. There's other things too, like a picture of a bloodied up victim, something like that. That would be problematic in terms of unfairly prejudicing the jury. Waste of time is another thing, just cumulative evidence, more and more evidence of the same stuff you've already demonstrated. So these are different factors, but the big one is unfair prejudice. But certainly waste of time can also be there.